Hi. Hello. I'm here. Hi, hi, hi. What is up? Hello, everyone. Can you guys see me and hear me okay? Per usual, StreamYard, YouTube, everyone's been acting up today. Hello. I'm not, though. I might be now. Hello, hello. Shout out to Cree. Hello, abuelitas. And I saw Benjamin, Lisa, Tara, Debbie, Carrie, Hiller. Oh, and Vanjie, First Liberties. Hello, hello. Happy Thursday. I couldn't be more excited that it's going to be Friday. There's many things I want to talk about, but we're going to talk about Courtney Clenney right now. I might be dropping a short regarding 𝐼𝐸 case, also about the harassment I've been receiving lately. I will also be touching base on that. So just turn on your notifications, please, so you don't miss any videos. YouTube does what they want. Love them for it, but sometimes I send out notifications, sometimes they unsubscribe people, sometimes they do things that we have no control over. So definitely make sure you turn on your notifications. Please hit the like button. It really helps my small little channel. And welcome. I am Melly, by the way. This is my channel. I am your host. And welcome to Mellyverse. If you are a new subscriber or a new viewer, shout out to all the mods, the members, my friends, the haters, all of you. Hello. We're going to be talking about Courtney Clenney tonight. We're going to be reading the new motion that was recently filed. I did get it from the court. We're going to just get right through it. If you know and you've been listening to me reading documents, we'll probably get through this pretty fast. And this is the third time that Courtney is attempting to get bond. She has been denied twice. If you're not familiar with the Courtney Clenney case, please, 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 please check out the playlist. I have all the body cam footage. I've been covering it, although this case hasn't been out. I know it's a popular case, but there's been things going on behind the scenes. Like there's the instance with the laptop and her parents that got dropped. There's a situation, if you were here for 2 lives ago when I did covered Courtney Clenney, we read that, the defense team wanted the DA and the prosecution people to be dismissed off the team because of their prosecutorial misconduct. And Courtney Clenney is the OnlyFans model that, and for YouTube purposes only, she punctured, if you know what I mean, her boyfriend to death. And she's claiming self-defense. You let me know what you think about the case. I think we're all pretty much there. It's been just kind of, like I said, behind the scenes because there hasn't been much going on, but there has been in regards to documents. And I have covered those. So definitely make sure you check out the playlist. She has trial coming up, and here she is again requesting basically bond again because of the misconduct. And we're just going to read right through the document. I believe this is going to be the first trial that I stream consistently and all throughout it. So I'm really excited. Unless something comes up. Yeah, I don't know. But pretty much, yeah, we're starting from the beginning with her. Pretty sure it'll be live. So thank you for being here. If you see smoke, don't worry. I'm not on fire. It's my candles and such in the background. Like I said, thank you for being here. Let's get started. The last Kenzie live. Oh, yeah, I don't want to go too much into detail about that right now, but maybe after this, I'm going to do an after dark and we can get into that. It's back up. It's all good. We're all good. Hey, Patronus. Okay, let's get started. Here we go. This is motion for reconsideration of bond. We're going to start right from the beginning. I'll skip through the parts that we don't need to hear. The whole Article 1, Section 14, et cetera, factual and procedural history. The state has charged the defendant, Courtney Clenney, in the death of her boyfriend, Christian 𝐸𝐸. The events leading to the death of 𝐸𝐸 occurred on April 3rd, 2022 at the apartment of the defendant. Mr. 𝐸𝐸 was not on the lease and was only an authorized guest that stayed with her. All rent was paid for by the defendant, Courtney Clenney. Prior to April 3rd, 2022, Miss Courtney Clenney attempted to remove the decedent from the apartment. Miss Deborah Clenney, Courtney's mom, flew to Miami to help her daughter remove the decedent from the premises. The decedent attempted to remain on the premises by secreting himself in the common areas of the building and other areas of the complex, as he had no means of income to obtain alternate accommodations. After these events, the decedent was able to manipulate Miss Clenney to successfully access her apartment. This was after he sent close to 200 unanswered text messages to Miss Clenney during the time period that he was no longer welcome in her apartment. Shortly after April 3rd, 2022, underside counsel was retained by both Miss Clenney and her family to represent all parties. During the months prior to her arrest, underside counsel was in constant contact with both Miami SAO and the City of Miami Police Department. Undersigned communicated with both agencies to arrange for Miss Clenney's self-surrender should a charging decision be made. After the events of April 3rd, 2022, Miss Clenney sought treatment for her substance abuse issues and her post-traumatic stress disorder. This ultimately culminated with her paying for and traveling to Hawaii. There she attended an inpatient program that specialized in treating both issues. Again, at all times, Undesigned counsel was in contact with both the Miami SAO and the City of Miami Police Department investigators. On August 10th, 2022, the defendant Courtney Clenney was formally arrested and charged with second-degree homicide via an arrest warrant and the use of SWAT teams located in Hilo, Hawaii, where she was attending the inpatient treatment program. Despite previous communications, neither the Miami SAO nor the City of Miami Police Department contacted counsel to arrange for her self-surrender. Following an Arthur hearing and pretrial detention hearing held on November 15th and 17th of 2022, the court ordered Miss Clenney to be held without bond. Miss Clenney has remained incarcerated since her arrest on August 10th, 2022. Now, do you believe she was acting in self-defense, or do you all think she's batshit crazy? Because if you have watched the lives and the body cam footage, either here or somewhere else, she reminds me a lot of Mackenzie. Like, I definitely think there was mental health issues there, a lot of violence in that relationship, and toxicity as well. I've been waiting for this trial. Yes, me too. Nama Owens, I saw your comment. I do want to cover what's been going on over there at her channel. I've also covered it a little bit, but I will share with you guys on a different live. I followed this from the beginning. My heart broke for her boyfriend. Yeah, it's a really sad case. Okay, so factual and procedural delays caused by government misconduct. On November 3rd, 2023, the City of Miami Police Department obtained and executed a warrant on the iCloud accounts of Miss Clenney's parents, Mr. Kim and Miss Deborah Clenney. This warrant, essentially identical to the one issued in March of 2023 that had expired, sought the entire iCloud accounts of the parents from November 2020 to March of 2023. The warrant application, excessive both scope and time, sought access to the entire iCloud accounts of the parents from November 2020 to present, extending to March of 2023. Despite the application's description of specific information sought with a limited time frame, law enforcement requested to access the entirety of the iCloud accounts. This included data from the 17 months prior to April 3rd, 22 incident, and data from 7 months after Courtney Clenney's incarceration, when she didn't have access to a mobile phone to connect with her parents or her counsel. As a consequence of the information obtained from this overly broad warrant, law enforcement accessed privileged communications between attorneys Frank Prieto and Sabrina Puglisi and their clients Courtney Clenney, Kim Clenney, and Deborah Clenney, which occurred after Courtney's incarceration. These communications took place in a group text that titled, quote unquote, Team Courtney, involving the attorneys and the paralegal investigator and Kim and Deborah Clenney and Courtney Clenney prior to her arrest. At no point did anyone from the state's attorney's office contact counsel to ascertain whether Kim or Deborah Clenney were represented by counsel, despite knowing that counsel represented their daughter. Nor did they reach out to Mr. and Miss Clenney, who were listed as state witnesses, to inquire about the representation in order to filter their names from any subsequent search. Sorry, I can't say that word. If you missed the last live, like I said, we did cover that document where they try to remove some people in office because they were sharing documents and such. It's a very interesting document, so definitely make sure you go catch up there. Is this the girl who said she threw it in and it stuck in? Yeah. Her parents make her look more guilty by doing this. I remember when this horrific tragedy happened, how Melly has been the only creator scene that is still covering it. Thank you, Potato. Yes, I have been covering it. I've kind of been obsessed with this case from the beginning. Let's see. Quinnen, that's his last name from the ASA Quinnen. He's the one that they wanted removed because of sketchy behavior. ASA Quinnen attempted to justify his search of these overly broad materials by stating that he asked counsel for contact information that should be subject to a filter. However, he failed to disclose that he intended to serve a warrant on iCloud accounts. He deceptively indicated the alleged filter was sought for and would only be applied to Miss Clenney's phone. Neither law enforcement nor the state's attorney's office established a filter to prevent the review of attorney-client or work product privilege communications as applied to any of the iCloud accounts. Consequently, privileged communications were reviewed by both law enforcement and the state attorney's office. ASA Quinnen conducted a search of the iCloud accounts and discovered the Team Courtney communications. The content of the Team Courtney chat involved discussions regarding all matters related to Courtney Clenney's case, including communication regarding case investigation, witness testimony, defense witnesses, expert witnesses, financial obligations, defense theories, counsel's thoughts and impressions and opinions on the case. These were communications that the parties believed to be private and privileged. During the unlawful review of privileged communication by the state attorney's office and law enforcement, they uncovered discussions about a laptop in the possession of the Clenney family and the defense's investigation into its potential evidentiary value. The state attorney's office, relying solely on the privileged communications and without any additional evidence, filed an information in F24, charging Courtney, Kim, and Deborah Clenney with unauthorized access to the laptop. When drafting the arrest warrant for defendants Kim and Deborah Clenney, ASA Quinnen approved the inclusions of attorneys Frank Prieto and Sabrina Puglisi as uncharged individuals who allegedly committed the crime alongside the charged individuals. It was only later that the state attorney's office conceded that the undersigned counsels had not acted improperly. However, these accusations were made public in the warrant application information and multiple written pleadings by the state, even after confessing in open court that the attorneys acted appropriately. In unrelated written communication, Quinnen asserted that upon review of the messages pertaining to the laptop, he immediately ceased review and went to obtain counsel from his supervisor, co-counsel, state attorney's office, appellate counsel, and defense attorneys. On June 26, 2024, the court entered an order granting a motion to exclude and or suppress filed in cases, etc., on the laptop caper. The order found that the communications reviewed by the ASAs and law enforcement were privileged as attorney-client and or work product communications. On August 20th, 2024, the defense filed a motion to disqualify the state attorney's office based upon the review of the Team Courtney chat. Subsequent to the filing of the motion, the defense was made aware of an additional and even more egregious breach of the privilege by Assistant Attorney Khalil Quinnen. After a public records request made by a third-party defense attorney, it was revealed that ASA Quinnen had also accessed another privileged communication sent from attorney Sabrina Puglisi to Courtney Clenney's parents. This communication included an attachment titled, quote unquote, Courtney checklist of things to do. Upon opening the communication, the first page of the document clearly displayed the fields from, sent to, subject, and attachments, with the from being the attorney, for Courtney Clenney and the attachment specifically named as the Courtney checklist of things to do. Judge Cruz permitted the defense to take the deposition of ASA Quinnen to determine the extent of the breach into the defense camp and the violation of attorney-client slash attorney work product privilege. ASA Quinnen, in the most unusual manner, filed a self-serving notice of withdrawal from Ms. Courtney Clenney's case, attaching his own interoffice memorandum on March 3rd of 2025. After the deposition of ASA Quinnen, the defense filed their amended motion to disqualify the Miami-Dade State's Attorney's Office. A hearing was held on the motion. Judge Cruz ultimately denied said motion on the grounds that the prosecutorial misconduct appeared to be limited to only the verified misconduct of ASA Quinnen. This order was entered on July 2, 2025, approximately 18 months after the defense first began to uncover misconduct on behalf of the state of Florida. So here's my thing is like, yes, there's a lot of damning information against Courtney. We've seen it. What do you think? But also, like, you have to remember, like, will the jury see it this way? And in my opinion, if we're going to play devil's advocate here, they have messed up. First, there's a case with the parents. Those charges ended up being dropped. Then there's ASA Quinnen. Okay, now he's gone. And I just feel like they don't, I've said this in a previous live, I think. The state doesn't need to be behaving like this when there's so much reliable evidence against Courtney Clenney. I feel like the body cam speaks for itself, but that's just my opinion only. I'm not a cop, I'm not a lawyer, I'm not a judge. But that's just my opinion. I do feel like that speaks for itself. So I'm curious to see what happens after this, if anything, before trial. Yes, they would, JLo. Hey, Ruth, good to see you. I'm glad you made it. Thank you for being here. Hey, Skater. I'm obsessed with the case. The videos are insane. Yes, sounds like you guys are all familiar. Hey, Moonchild. Let's continue. The argument is, in Florida, the standard for a substantial change in circumstances that may warrant a judge to reconsider a defendant's bond or the status of no bond after an Arthur hearing, pursuant to Florida Rule of Criminal Procedure, focuses on demonstrating a change in circumstances or new evidence that was not available at the time of the initial bond decision. The state must present evidence that convincingly shows changed circumstances or new information to justify a modification of the bail order. There is no requirement that the defense make a showing of substantial change in circumstance. However, in the matters sub judice, there's been significant and massive delays, approximately 18 months, caused by the government's misconduct, as referenced above, that constitutes a substantial change in circumstance. Yeah, so they're like, listen, with all that crap going on, and the fact that you got all of these people at, the state's office acting out of hand, she should get bond. I don't know. If she gets bond, wouldn't her trial start still on the 1st? I don't think it would get pushed back, right? She would just be out until the trial and during the trial, I'm assuming. I don't know. What do you think? Do you think she should get bond? I can't wait for this trial. Yes, and if I stream it, you better be here. You better be here. So Yvonne Morales, yes, I can give you a little overview of this case. Courtney Clenney is the OnlyFans model that stabbed her boyfriend in a hotel in Miami. Well, it wasn't a hotel. I take that back. It was a nice apartment in Miami. And she stabbed him, according to her, in self-defense. But there's a lot of information that proves otherwise. She was abusive. They were in a toxic relationship. It was a lot like Mackenzie, Sharilla, and Dom in terms of how they talked to each other, respected each other, etc. And allegedly, she had a substance problem and health issues. Who knows? There's evidence that she was like this with her ex-boyfriend. If you have seen that, if not, I'll definitely be sure to cover it. But she's an OnlyFans model making a lot of money at the time of her arrest. And she has been fighting to get bond, has been denied twice. And here she is again. But there's been a lot of things going on behind the scenes with the case, and she's getting ready for trial. So that's pretty much sums it up. Yeah, I think it would be televised. No bond. This is the first time she harmed him, just the first time he didn't survive it. That's right, Shasta. That's right. I agree with that. Okay. Significant delay in the adjudication of Miss Clenney's constitutional right to a speedy trial has been severely affected by the state's invasion of the defense camp, viewing of protected communications, and filing of frivolous new charges. Further, Judge Cruz's denial of bond, Miss Clenney, was based on evidence she received from the state during the Arthur hearing. The state submitted to the court as part of their Arthur hearing packet certain recordings. These recordings were surreptitious recordings made by the decedent of Miss Clenney in violation of Florida Statute 934.06. These felonious recordings are a clear violation of law, and the legislator has made it abundantly clear they are per se inadmissible as evidence in any type of proceeding. This statute states that whenever any wire or oral communication has been intercepted, no part of the contents of such communication and no evidence derived therefrom may be received in evidence in any trial, hearing, or other proceeding in or before any court, grand jury, department, officer, agency, regulatory body, legislative committee, or authority of the state or a political subdivision thereof, if the disclosure of that information would be a violation of this chapter. The surreptitious, unlawful, misleading, and felonious interceptions should not have been considered by the court in making a bond determination. This statute was designed to effectively protect the privacy of oral and written communications and to protect the integrity of court and administrative proceedings. In Florida, the statute into law, the legislator in passing Florida Statute 93, the statute we're talking about, 934.06, into law, the legislator unequivocally expressed its desire to suppress evidence obtained in violation of that chapter, making it clear that these type of recordings are not admissible under the circumstances in this matter. Additionally, the weight of the evidence has shifted with the discovery of additional evidence and expert witnesses to support the defense of justifiable homicide/self-defense. At the time of the Arthur hearing, the defense argued that the motion for pre-trial detention should be stricken because the court may order pre-trial detention if it finds a substantial probability based on a defendant's past and present patterns of behavior that the defendant has previously violated conditions of release and that no further conditions of release are reasonably likely to assure the defendant's appearance at subsequent proceedings, or the defendant poses a threat of harm to the community. The court may so conclude if it finds that the defendant is presently charged with a dangerous crime, that there is a substantial probability that the defendant committed such crime, i.e., second-degree unaliving. The factual circumstances of the crime indicate a disregard for the safety of the community, and that there are no conditions of release sufficient to protect the community from the risk of physical harm to persons. Additionally, the court should consider criteria. The factors relevant to this case are A, the nature and circumstance of the offense charged, B, the weight of the evidence against the defendant, C, the defendant's family ties, length of residence in the community, employment history, financial resources, and mental condition, the defendant's past and present conduct, including any record of convictions, previous flight to avoid prosecution, or failure to appear at court proceedings, the nature and probability of danger which the defendant release poses to the community, the source of funds used to post bail or procure an appearance bond, particularly whether the proffered funds, real property, or any proposed collateral or bond premium may be linked to or derived from the crime alleged to have been committed or from any other criminal or illicit activities, whether the defendant is already on release pending resolution of another crime proceeding or on probation or parole, the nature and probability of the intimidation and danger of victims, whether there is probable cause to believe that the defendant committed a new crime, and any other facts that the court considers as relevant. The state has selectively presented parts of the discovery to the court and the media, creating an incomplete and inaccurate picture. At the time of the Arthur hearing, the defense had not yet fully evaluated the extensive discovery materials. Although there were no witnesses to the events in the apartment on April 3rd, evidence indicates that Miss Clenney and 𝐕𝐤𝐲𝐬𝐞 had a tumultuous relationship. During the Arthur hearing, the evidence was biased, portraying Miss Clenney as the instigator with violent tendencies, e.g., elevator video, surreptitious recordings that were improperly considered by the court. Since then, the defense has discovered a key witness corroborating 𝐕𝐤𝐬𝐬's physical abuse, wow, of Miss Clenney. Arthur Cupp, a witness known to the state during the Arthur hearing, told police via body-worn camera footage on the incident date that he previously saw 𝐕𝐤𝐬𝐬 pummeling Miss Clenney from his apartment across the street. Compelled by what he observed, Mr. Cupp, a neighbor with a direct view into Miss Clenney's apartment, approached the police on the incident date to report his observations. Wait, was that on body cam or no? Because I don't remember that part. There was a neighbor that said that. Medical report says her story doesn't match. Yeah, I don't think her story matches. I mean, they brought the pig carcass, remember, into the courtroom. That's this case. That's true. I believe the motion to suppress was granted. The DA was wrong to lock up the lawyers as co-conspirators, and the judge let them out. Yeah. The state examiner will say one thing, but the defense expert may say something else. I want to hear what defense experts have to say. Her boyfriend did play college football, also had an engineering degree. That's right, F. Owens. Thank you. Patronus says, I don't remember yeah, me either, Patronus. I think that's why it's coming out in this motion, I think. Hmm. Statements from the other neighbors document 𝐕𝐤𝐬𝐬 acting aggressively towards Miss Clenney in the days leading up to April 3rd, 2022. Interviews conducted by the City of Miami Police Department after the events demonstrate that Miss Clenney was clearly a victim of domestic violence. These statements, along with the reports from the security personnel who contacted law enforcement less than 48 hours before 𝐕𝐤𝐬𝐬's death after witnessing him aggressively charging at Miss Clenney in the lobby, support this assertion. During that incident, Ms. Clenney implored the police for a restraining order against 𝐕𝐤𝐬𝐬, and her pleas were documented on the body-worn cameras of the responding officers. Mr. Cupp, a defense witness unknown to the defense at the time of the Arthur hearing, was unable to provide his testimony for the court's consideration. Additional evidence supporting Ms. Clenney's claim of self-defense includes testimony from the defense experts Bobby Branton and Dr. Maricini, who will assert that the knife in question could be thrown and penetrate the decedent to a depth of nearly 3 inches with a slight downward angle. Ms. Clenney consistently stated to initial responders and later at the police station that she threw the knife in self-defense. The state's medical examiner testified that in his opinion, it was not possible for the knife to have been thrown as Ms. Clenney claimed, though he admitted he was not a knife-throwing expert. The defense experts' testimonies validate Ms. Clenney's statement and corroborate that her actions were justified. Finally, the world's leading expert on battered spouse syndrome, Dr. Lenore Walker, is expected to testify at trial that Ms. Clenney was suffering from the battered spouse syndrome. Dr. Walker will testify as to Courtney's state of mind at the time she was forced to take the action in the defense of her life. I am familiar with Dr. Lenore Walker, and that's wild. Like it says, she is the world's leading expert on battered spouse syndrome. Of course, the OnlyFans model would have such an exquisite person on her team. Hey, Brenda. Hey, Kiraha. I remember seeing the neighbor footage. I wondered why they did not call the police. Really? I wonder if I had it in my lives and I just don't remember. Hey, April. My favorite channel to go for the good gossip. Yes. Thank you for being here, April. Oh, no. Well, I hope your boyfriend is okay. Now my boyfriend's having chest pains while we wait. I'm sorry. Being at the hospital sucks. Sending you and your boyfriend good vibes. Hope he's okay. You're fine, Brenda. Thank you for being here. Let's continue. Previously in the state's pretrial detention memorandum, the state inaccurately claimed that Ms. Clenney immediately fled the jurisdiction. State's pretrial detention memorandum at page 9. In reality, Miss Clenney, through her counsel, maintained consistent contact with law enforcement. She did not flee, but instead returned to her home in Texas, where she and her family resided before her relocation to Miami to seek treatment for PTSD and substance abuse issues. I can appreciate that, like, that she went and got help and was doing what she needed to do. But honestly, like, why didn't you do that before when you were putting hands on your boyfriend and you were getting in trouble and drinking all the time, etc.? Like, and clearly there's no history of that because I think it would be in the documents, right? Like the defense would be saying, look at here. In 2019, there might be actually, now I take that back. There might be an instance of her seeing like a therapist or something before, if I remember. Who knows? Don't come for me if I'm not right. But I'm just saying, why aren't we hearing about it here? I sent the link to my boyfriend. He's hooked with Mellyverse too. Really? That's hilarious. I'm glad y'all are bringing your boyfs. We're gonna call them boyfs, boyfriends. Yeah, sending good vibes. Exactly. Okay. To bolster their request for pretrial detention, the state further. Oh wait. Yeah. Okay. To bolster the request for pretrial detention, the state further argued that Ms. Clenney fled the Texas jurisdiction to California. This assertion is also false and misleading. Ms. Clenney had a pending misdemeanor DUI in Texas and traveled out of state because there was no court-imposed restrictions on her travel. That case has since been resolved. Florida statute requires that the defendant pose a threat of harm to the community. The evidence in this case does not suggest Courtney is a threat to the community. She has no prior criminal history that involves violence or a threat to someone other than Mr. Obumseli. The circumstance and evidence which now show that she was the actual victim. Wow, the actual victim. The state also argued that the transfer of funds from Courtney to her father on April 3rd, 2022, while the investigation was pending, was a quote unquote apparent effort to relocate and conceal assets. State of motions for pretrial detention on page 10. In reality, not me being dyslexic again. In reality, Kim Clenney took over managing his daughter Courtney's financial obligations after April 3rd, 2022, because she was suffering from PTSD and excessive alcohol consumption. I want to tell you guys my secrets. Beliefs, yeah. Tell me what you think, please, in the chat and in the comments. Like, should she be out on bond? I don't know, you guys. I don't know. Why do I feel like she might get bond? She might get it. Let's continue. While funds were transferred to Mr. Clenney, it was not tied assets. All expenses, including the largest expense of attorney's fees for Courtney's defense, are fully accounted for by Mr. Clenney. The funds to pay a bond in this matter would come from her parents, as Courtney is essentially broke. Courtney is essentially broke. All her money is spent. Nah, I don't think she's broke. Her home is in foreclosure, and any equity that she will be able to salvage has been earmarked to pay overdue expert and attorney's fees. Oh, her home is in foreclosure. Finally, as indicated above, I didn't know that. They hadn't said that in any of the documents before. Finally, as indicated above, the state has acted improperly in numerous aspects. 1, presenting an overly broad warrant application. 2, failing to implement proper filter protocols to ensure attorney-client privilege communications were not reviewed. And 3, reviewing attorney-client communications in violation of the law. As a direct result of these errors, Ms. Clenney remains in custody, with her having remained at a standstill for about 18 months. Law enforcement, with the approval, assistance, and at the direction of the state attorney's office, filed an affidavit supporting a search warrant for Kim and Deborah Clenney's iCloud accounts. The warrant saw everything on the iCloud: photographs, texts, emails, notes, etc., of Deborah Clenney due to messages exchanged with Courtney Clenney immediately after the incident on April 3rd, and known photographs taken by her mother. It also sought Kim Clenney's iCloud data due to the commingling of funds between him and his daughter after 𝐈𝐨𝐲𝐬's death. The warrant covered a period of 17 months before and 10 months after 𝐈𝐨𝐲𝐬's death. The privileged communications read by the state attorney's office were made after Ms. Clenney was in custody, during which she had no phone communications with her parents. There was no valid reason to request or review these communications, as they were irrelevant to the investigation and inconsistent with the warrant's application reasoning. Attorney-client privileged communications are sacred. Every state attorney's office has protocols to ensure such communications are not breached. In this case, at the very least, ASA Khalil Quinnan made no attempt to determine if Kim and Deborah Clenney were represented by counsel. There is no obligation for their attorneys to inform the state of their representation. Mr. and Ms. Clenney, they are listed as state witnesses, so the state attorney's office could have easily contacted them to ask if they had counsel or contacted undersigned counsel, knowing they were the parents of his client and would likely know if they were represented. The more likely answer is that the state attorney's office did not want to tip off the Clenneys that they had sought a warrant for the communications because they simply view everything through prosecutorial blinders as reasoned by Judge Cruz in her order suppressing evidence. The state attorney's office admitted to having reviewed attorney-client communications and desperately tried to make frivolous arguments justifying their review. Despite having no evidence to support their theories, the state continued to litigate this matter through extensive motion practice, delaying this matter even longer. The court ruled that the attorney-client relationship existed, the communications were privileged, and no exception justified the state's review of such communications. Initially, the state argued that the no attorney-client privilege existed due to a conflict of interest for undersigned counsel representing them. The state misunderstands the proper procedure for a potential conflict. It is not to unilaterally decide there's a conflict, thus negating privilege. The state attorneys should have mentioned the court, advised of the potential conflict, and saw the court's review to determine, one, if the conflict existed, and two, if the clients could give a valid waiver of any conflict. Instead, the state attorney's office made the decision unilaterally. Additionally, the warrant application incorrectly stated that the parents could not be represented because they were listed as state witnesses. No case law supports the notion that a state witness is precluded from having representation. Although the detective wrote the warrant application, he testified that ASA Quinnan essentially assisted him in the legal portion of the application. While ASA Quinnan claims to have only read a small portion of the communication related to the laptop subject to a now dismissed charge, it is questionable whether this is reasonable. If ASA Quinnan believed there was no attorney-client privilege, what prevented him from reviewing the entirety of the communication, which discussed defense theories, witnesses, experts, financials, etc.? Because of the above delays, Ms. Clenney's aggressive defense grinded to a halt, having to defend new charges and refusing to continue discovery with prosecutors who should not be handling the case. This delay could and should have been avoided had the state attorneys followed proper protocols. What do you guys think? No, you didn't. It does seem the state has biased the trial at this point, but I doubt the remedy is to let her out of holding. It's normal for people to be locked up during trial when someone dies. Yeah, I was just thinking maybe because, of all the errors or the misconduct, quote unquote. Wow, I thought she had millions spent it all. I think she was worth like 3 mil estimated from OnlyFans prior or at the time of this crime, because YouTube, let me get a drink of water. Okay. I always mute it because I don't want you guys to hear me. Conclusion. The evidence, now more fully evaluated, reflects a long history of mental, emotional, and physical abuse inflicted by Miss Clenney's abuser, 𝐕𝐨𝐲𝐬. The calculus has shifted in favor of granting a bond in this matter when considering the defense's experts' testimony and anticipated testimony in this matter. Additional defense witnesses have been located that corroborate the abuse Ms. Clenney faced. The court can impose conditions to ensure Courtney's appearance in court and the safety of the community. The defense recommends a monetary bond with special conditions, including home confinement. Hey, Jamie Komorowski got the home confinement, if you remember. And I thought they just said she was broke, but now she has money to do bond. Didn't they say she was essentially broke? They're making aggressive and potential viable arguments. All her money is going to the defense, most likely. These are very viable arguments. That's why I said, oh, she might get it. She might get home confinement, which is basically house arrest. Which is ridiculous, but hey. The defense recommends a monetary bond, which, I already read that, sorry. Ms. Clenney can participate in an electronic GPS monitoring system from her home in Texas, with the program providing regular reports to the court in the state. She should also attend an outpatient program for PTSD and alcohol drug abuse. The defense requests that the court release her to the custody of undersigned counsel to travel with her to Texas and ensure the monitoring system is implemented. Ms. Courtney Clenney respectfully moves this honorable court to reconsider the denial of a reasonable bail in this matter, given the delays caused by the state's misconduct, the strength of the defense case, and the expert witnesses who will testify to the reasonableness of Ms. Clenney's actions. This was filed on October 10th by the Prieto Law Firm. Exhibit A is the order denying release. So this was the, I believe, first document. Defendant shall continue to be held without bond pending trial. In this case, defendant is charged with an offense punishable by life imprisonment. Defendant's guilt is evident and the presumption of her guilt is great. To this court, the meaning of the phrases evident proof and great presumption of guilt have always been ambiguous. The court does not believe the state's evidence was rendered doubtful by substantial contradictions or discrepancies during this Arthur hearing. There is no dispute that a defendant unalived victim in this case. The only factual issue is whether the defendant was acting in self-defense and whether this claim rendered the state's evidence doubtful. Clearly, defendant and the victim had a sadly volatile relationship. There's ample evidence of communication in the form of text, videos, letters, and audio recordings of how unhealthy their relationship was. However, from the evidence presented during this hearing, the court does not find the defense claims of self-defense on April 3rd, 2022 credible. Therefore, this claim does not render doubtful the state's case. Defendant's statement to police about her involvement in the victim's death is not supported by other evidence from the hearing. So this is the bond, or this is a motion where she was denied previously. Defendant's version of how victim's stab wound occurred is not supported by the evidence. In her statement to police, defendant stated that she threw a knife at the victim from 10 feet away. Defendant's interview on April 3rd. However, the medical examiner testified that the victim was unalived by a knife wound that went down into the soft tissue and into the muscle and injured the subclavian artery. He went on to testify that the victim's stab wound was 8 centimeters deep and traveled from the front to the back in a slightward down trajectory. The medical examiner opined that at least 8 to 12 pounds of pressure would have been used to penetrate the skin and muscle into the artery itself. When asked whether the victim's stab wound could have been caused by a thrown knife, the medical examiner answered no. Defendant's speculation over whether the knife could have been pushed in, whether victim or defendant was trying to remove it, is not persuasive. Additionally, defendant's contention that she grabbed the thing you eat your steak with only to scare the defendant and threw it at him with no intention of injury is undermined by the fact that the defendant had intentionally cut or punctured victim twice in the 6 months leading up to this incident. Wait. Oh, because they have evidence of that. On October 8th, 2021, defendant stabbed the victim in his leg. On January 30th, 2022, defendant cut victim in the face, causing multiple lacerations, which required stitches. Defendant clearly had no fear of using a knife as a weapon without close proximity to victim, as there are no allegations that a thrown knife caused those injuries. So they have two instances where she did this to Christian. She just wants to glam up for trial, right? I think her motion overlooks the race factor. Yeah, I think it does too. Florida is well known for due process violations. I can see the judge making some kind of adjustment, but the government will probably forgive itself at the same time. Yeah, what does race have anything to do with it other than one's white and one's black? I don't think there was a race factor. I don't think so. I think it was more of like she was privileged because she wasn't arrested initially and they went arrested her in Hawaii. But I digress. Okay. Let's see. Although defendants claims victim held her down by the neck at some point prior to the incident, there's no physical evidence of this. Her description of this event changed slightly each time she explained the event to the police, making the statement less credible. Although defendant did have bruising on her body, notably there was none to her neck. Photos and videos show that the only significant bruises were prior to the incident, as was the damage to her fingernails. Evidence clearly shows that a defendant was on the phone with her mother during some portion, if not at all, of this incident. However, during a 20-minute recorded interview with police, defendant's mother never once mentioned that there was any physical violence or verbal threats from the victim towards the defendant on that day. Defendant's mother says that she heard yelling and that the defendant told victim to leave, but never once does she say that the defendant was in fear that day or being harmed in any way. Immediately after the incident, defendant's mother texts her daughter not to speak with police without an attorney, describing the incident as self-defense. However, when asked by police whether she heard her daughter say anything that day, specifically whether she heard any threats from the victim towards the defendant, defendant's mother says nothing. She does not tell police of any verbal threats to the defendant or a physical attack by victim that day. At this point, evidence of defendant's use of self-defense on April 3rd is not credible. Based upon the evidence from this hearing, the court does not believe that the state's evidence was rendered doubtful by substantial contradictions or discrepancies shown by the defense. Therefore, the court finds that the state has met its burden of showing the proof that defendant's guilt is evidence. The court finds that there are no release conditions, which this court believes can assure the appearance of defendant at future hearings and or protect the safety of the community. Defendant has no ties to Florida and ample means to leave the country where she chose to do so. The defendant has millions of dollars at her disposal and the ability to make more outside of the jurisdiction of the United States. The state is correct that a defendant's criminal history in previous cases shows defendant did not abide by the terms of her pre-trial release conditions, at the very least, picking up new cases when out on bond. In those cases, defendant was facing little jail time and still did not abide by the court's orders. The court is concerned about what defendant might do when faced with the possibility of life in prison. The court does not agree that placing defendant on house arrest with her parents in Texas is appropriate form of release in this case. This finding does not end our inquiry because the state filed a motion for pretrial detention. The Florida legislature has expressly authorized the court to order pretrial detention if it finds a substantial probability based on a defendant's past and present patterns of behavior and any relevant facts. In this case, there are several factors that demonstrate defendant's threat of harm to the community and the need for pretrial detention. As noted above, the defendant has no ties to the state of Florida. This court has considered the nature and circumstances of the offenses charged. As stated above, the defendant is facing an offense punishable by life, namely second-degree murder. This court makes the following findings. The defendant is charged with dangerous crime. Again, remember, this is the bond that got denied before. There is substantial probability that defendant committed this defense. The factual circumstances of this crime indicate a disregard for the safety of the community. There are no release conditions which this court believes can assure the safety of the community. Defendant poses a risk of flight for the reasons stated above. The state's motion for pre-trial detention is therefore granted. Exhibit B was filed on January 26, 2024, and this is an order granting defendant's motion to suppress and or exclude, dismiss of prosecutorial misconduct. The court has read defendant's motion. It is hereby ordered and adjudged. Defendant's motion to suppress and or exclude is granted. The court finds that Courtney, Kim, and Deborah Clenney have all been represented by Frank Prieto and Sabrina Puglisi since September of 2022. The communication sought to be excluded by the parties is protected by attorney-client privilege and or work product privilege. This privilege was violated when the communication was read by prosecutors in this case. The court finds that the crime fraud exception for privileged communication under Florida statute does not apply to this case because of the state of Florida has made no prima facie showing that a defendant knows their communications could be an alleged crime. And then Exhibit C is the order granting in part defendant's motion to compel the deposition of Assistant State Attorney Khalil Quinnan. If you want a read through of that document, check out the last live. There's a Courtney Clenney playlist. I'm not going to read through this here because, like I said, I read through the whole thing and discussed it in the previous live. Let's see. That's it. I don't know. I'm gonna keep my eyes on the docket to see what happens with this. She also stabbed him previously. I know. I don't know. I'm like 50-50 on this. I think she might actually get bond, perhaps just before trial or while waiting. She's definitely privileged, right, Cree? But then a part of me thinks maybe not. Maybe she's gonna get denied for the third time. You know, they say third time's a charm. My heart broke when officers arrived. No one knew what was happening. And yeah, I know. The video of Christian where he's like, I'm gonna die. Yeah, I know. I truly believe those bruises were from him defending himself and pushing her away. She came at him strong. Yeah, I mean, I don't think she threw that knife. I really don't believe that. But I do feel that, the state has made a lot of errors as well. Question mark, question mark. Yeah, I haven't decided yet. So I'll definitely keep you guys updated on Courtney Clenney. Like I said, trial is December 1st. I don't think she'll get a bond. She's a flight risk. Yeah. Yeah. She's a flight risk, but at the same time, it's like she's famous. So I don't know. I don't know. I'm curious to see what happens for sure. I'm going to keep my eye on this. I might do another Courtney Clenney live this weekend on other stuff if I've missed anything. I'll definitely keep you guys updated. Definitely hit the like button, please. It is early here, so I might come back and do another live. So definitely turn on your notifications. I don't know. Melly. Donna Adelson and Charlie were privileged in Florida and repeatedly denied bond. That's also very true. She has been denied twice, Courtney Clenney. So it's possible she'll get denied again. But thank you for being here while I read that document. I will definitely keep you guys updated. Like I said, I can't wait for this trial. Is it possible she can wait? Can she still take a plea deal? She can still take a plea deal, right? No matter what is going on right now. We'll see. But I'll definitely keep you guys updated. Thank you for being here. Definitely make sure you check out the Courtney Clenney playlist. I don't see them letting her go to Texas, especially after finding her in Hawaii. Yeah, I agree. I don't know if we're gonna do a Kenzie live. I definitely will be back tonight for sure. So, like I said, definitely turn on your notifications. Thank you, thank you, thank you for being here. Shout out to all the mods, all the viewers, all the members. Hit the like button on the way out. I'll keep you updated on Courtney Clenney, and I'll see you on the next one.